This is Larry Bodine, Editor-in-Chief of Lawyers.com, and today we're in Chicago at the American Bar Association annual meeting. We're speaking with Rory Little, a professor of law at the University of California, Hastings College of the Law. Rory, I understand that if a person is driving down the street and they discover a GPS tracker on the car, that they have some new rights to assert. What's different now about GPS trackers?
Yeah, in the Jones case, the Supreme Court decided that the installation of a GPS tracking device and the monitoring of that device wherever you go is a Fourth Amendment violation if they haven't gotten a warrant. So you've got to get a warrant now. And this is huge because law enforcement has been using these GPS devices quite frequently. Now they're going to have to get a search warrant, which is a much more resource-intensive process.
Sort of a strike for the people's rights then. Wanted to also talk to you about the Florence case, which involved an African-American man who was a passenger in a car, was pulled over on a warrant which was no longer effective, and he was put in jail. What happened to him, and what did the Supreme Court say about it?
Yeah, the Florence case is really outrageous. This guy was arrested invalidly, stayed 7 days in jail, and was searched repeatedly, strip searched. And strip searching is a routine procedure in most jails. But the court had to decide, what if it's a minor offense or an invalid offense? And 5-4, they decided that this is reasonable under the Fourth Amendment. So if you're arrested even for the most minor offense, you can be strip searched.
So if I'm riding a bike down the street and I get arrested for not having an audible bell, I can be arrested and be strip searched?
Right, or if you're talking on your cell phone or you didn't wear your seatbelt, so long as they have the power to arrest you, you can be strip searched.
Something to bear in mind before you subject yourself to arrest.
Right.
And then the third case I wanted to talk about is, I understand that there's a new ruling that disallows mandatory life in prison terms for juveniles. What changed?
Right, there are 27 jurisdictions that make it mandatory that if you're convicted of the top level of homicide, you go to jail for life without parole, even if you're a juvenile. So once you're charged as an adult and you're a killer, you could get mandatory LWOP, we call it, life without parole. That is no longer valid, so 27 states will have to change their laws.
All right. Well, thank you very much, Professor Little. This is Larry Bodine reporting in Chicago from the American Bar Association annual meeting for the Lawyers.com channel.